6.
Well, good evening to you. We begin tonight with another legal setback for Governor Sanders. This one over her desire to set very late special election dates for 2 vacant seats in the Arkansas legislature.
The state Supreme Court has now denied her request to stay 2 lower court orders demanding she move up those election dates. Tonight, Channel 7 News asks, can the governor avoid complying with those court orders? Our Andrew Mobley joins us in studio with more. Andrew.
The 2 lawsuits both demand the governor comply with the state law requiring special election dates be set within 150 days after a vacancy opens, after she set elections far beyond that deadline. The law allows an exception if it is impracticable to hold a special election within that timeline. But Pulaski County Circuit Court judges didn't think that was the case when they ruled against the governor in both lawsuits. One filed by a Franklin County resident regarding the late Senator Gary Stubblefield's seat, the other filed by the Democratic Party of Arkansas concerning the House District 70 seat vacated by Representative Carlton Wing. The governor had set the special election for both seats on June 9th, 280 days after Stubblefield's seat became vacant, 252 days after Wing's. Both circuit court judges ordered that Sanders set the election sooner. In the case of House District 70 on March 3rd. But the governor says that expedited timeline would violate other laws regulating the election process, which her attorneys say cannot legally be done in less than 192 days. What with candidate filing election commission notices, runoffs, absentee ballots, and so forth.
I think that's not a persuasive argument because I think the 150-day statute trumps those other statutes because those other statutes are designed for normal circumstances, and the 150-day statute is designed for vacancy.
But what if it is literally impossible to hold an election within that timeline?
If she can demonstrate that, she should succeed.
The governor appealed both lawsuits to the Arkansas Supreme Court and asked that the lower court orders be stayed. But last night, the Supreme Court rejected that request. So even though the governor hasn't technically lost, by the time her appeal is resolved at the Supreme Court, it will likely be long past the special election dates demanded in lower court orders. So she will have to comply.
Maybe there's some other motion that the Attorney General will try to make to the Supreme Court, but frankly, I can't think of one. And I've been thinking about these types of issues for a long time. So I think that they're done.
Barring some impressive legal maneuvering by the Attorney General's office, if the governor continues to refuse to set earlier special election dates, she may be held in contempt of court. On your side, I'm Andrew Mobley.
Right, Andrew, thanks so much. And for more coverage of the legal battle over special election dates in Arkansas, visit KATV.com.